Everybody trying to take their seats. We it was like it was a bank in the early 1930s when we brought the pizza in, and I think everyone has food. Hopefully. I'd like to welcome everyone out to our panel today. My name is Brian Juden. I'm the president of the Federalist Society here at William & Mary School of Law. We are honored to have a great selection of participants at this panel. The panel is being sponsored by the Federalist Society and the Institute of Bill of Rights Law Student Division. Just as an announcement prior to going into the panel, this Friday and Saturday will be the annual Supreme Court preview. We are going to be passing around a list. On Saturday, we'll be having panels at 12 o'clock noon. Those panels are open to the public and anyone who wishes to attend, but we do need you to RSVP. The two panels that the Institute of Bill of Rights Law and the Federalist Society will be sponsoring, one is on race in the court. There's quite a few affirmative action cases kind of circulating in the news right now. And then the other is on Elena Kagan's first year on the court. We have some great panel participants. Dahlia Litwick is going to be on the Kagan panel, and then Judge Harvey Wilkinson of the Fourth Circuit Court of Appeals is going to be on the race in the court panel, amongst other people. So we'll be passing around this list. If you're interested in attending, if you'd like to RSVP, please put down your name, email address, and which panel you'll be attending. With that, I will turn the time over to our moderator, Professor Paul Marcus.
Well, hi everybody. It is a pleasure to be here at the first order of business. Those who are wearing jackets can feel free to take them off. It's pretty warm here. For those of you who are standing, there are some open seats. There are a few down here. If you have an open seat next to you, would you just raise your hand? So, yeah. So if you guys want to sit, feel free. There are a few seats. And we'll be out in time for 2 o'clock classes, because otherwise we will be chased out of this room. It is a pleasure to have all of you with us today. The issues we're going to be talking about today are pretty interesting, pretty controversial. And there's a case before the Supreme Court that we'll hear a little bit more about. This deals with the GPS tracking system. We'll hear a little bit more about that. And really much broader issues in terms of the Fourth Amendment, technology, and the warrant requirement. We have three really outstanding panelists with us today. Beginning at this end, and I do very short introductions, as I told my colleagues here. Professor Orin Kerr from the George Washington University School of Law, really one of the great experts in the country, particularly with respect to technology. Next to him is our own, at least for this semester, Melanie Wilson from the Kansas University Law School. Like many of you are in her criminal procedure class right now. And next to her is Steve Leckar from the law firm of Shainis and Peltzman. He represented the defendant in the D.C. Circuit, and in about a month, a little more, he's going to be arguing before the U.S. Supreme Court on behalf of the criminal defendant in the actual case in front of us. The plan here is to have Professor Kerr give a little bit of a 2-minute drill to just kind of bring you up to snuff with respect to the actual case that went up to the court and what the issues are there. And then I'm going to start throwing a whole bunch of questions to my colleagues on the panel. Each question, each of them will be able to respond to. Thereafter, and that'll take us a good bit of time, but we're going to save some time for questions from all of you. And the only point I would make is any question you direct, you can feel free to direct to an individual, but I'm going to let the other panelists weigh in as well. But that'll be about a half an hour from now. So without any further ado, I turn it over to you.
Great. Pleasure to be here. Thank you for coming out and letting us be your lunchtime entertainment. So the case is called United States versus Jones. It involves a criminal defendant from Washington, D.C., who ran a nightclub in Washington, D.C., and on the side was selling cocaine. Side offering. The government wanted to monitor his location in order to prove that Jones was involved in the narcotics conspiracy. So they attached a GPS device to his car and watched the location of the car for 30 days. That evidence then was used to help prove the conspiracy, the idea being that the government showed that the location of Jones's car was near the stash house where the drugs were kept at particular times. And so the issue in this case is whether the use of the GPS surveillance, either the installation of the GPS device or the use of the GPS device to determine the location of Jones's car is a search or seizure under the Fourth Amendment. The government did in fact get a warrant at an earlier stage of the case. That warrant had expired and was from a different jurisdiction, so it was not applicable to this case. But the issue really boils down to whether the installation and use of the GPS surveillance violated Jones's reasonable expectation of privacy, or was somehow a seizure of his property. And the two precedents to keep in mind are a first case called Knotts, K-N-O-T-T-S, and a second case called Kerr. There are cases from the early 1980s involving beepers. So in these earlier cases, almost 30 years ago, the government would install a monitoring device, have something, a beeper, radio beeper, that was inside, say, a box or some sort of piece of property that would then be put into the suspect's car, and that would allow the government to follow the suspect from a distance of, say, 100 yards or 200 or 300 yards in order to determine their location. And so the issue in the Knotts case is how different, if at all, is GPS surveillance from this radio beeper surveillance. In the Knotts and Kerr cases, the Supreme Court said there was no reasonable expectation of privacy in the physical location of a car on public roads. In the Knotts case, therefore, no warrant needed to install the surveillance device and to use the monitoring of the beeper on public streets. However, in the Kerr case, the Supreme Court said it is a search that does violate a reasonable expectation of privacy to use that monitoring device to determine the location of the monitoring device inside a home, such as, for example, a car gets driven into a garage, it's inside the home, the curtilage of the home, and therefore a warrant is required. So the issue today, 30 years later, is whether that Kerr-Knotts rule still applies, and whether it applies to GPS surveillance given the differences between GPS and the more primitive radio beepers from the 1980s. That's the case.
Well, thanks. That's 2 minutes, that's pretty good. I want to start with a big question, which is whether the D.C. Circuit got it right. The D.C. Circuit, of course, sided with the defense. It is the government that is appealing to the U.S. Supreme Court. And Steve, I want to start with you. I'm guessing you think the D.C. Circuit got it right.
I think that'd be a reasonable assumption. I think they got it right because
You might want to do the mic a little bit closer. So
our position is that however one looks at it, whether you look at it from the perspective of a seizure, when the agent surreptitiously attached a GPS to Mr. Jones's wife's vehicle without his knowledge or consent, or whether you look upon it as a search, so when they, by the same token, when they secretly installed the GPS device to the car, or when they remotely, relentlessly tailed him. Actually, they didn't even tail him. I want to point this out. The vast majority of the time that the GPS was operational, the agents were really following Antoine Jones. So what the issue distills down to following, is this different from people? And of course it is. GPS and light years different. They collect, it's a pervasive search substitute. It's an electronic search substitute that collects data, records data. It records the intimate details of one's movement over time in space. In Antoine Jones' case, they they recorded his movements every 10 seconds of the day, from the moment he drove his car in the garage to the moment he returned home at night. Every 10 seconds of the day, 24/7 for 28 days. We view that as constitutionally infringing the Fourth Amendment. They should have adhered to warrant, and they had a warrant in this case. They just let the warrant expire before they installed the GPS device. And then when the GPS device rebooted, when the GPS device ran down, they didn't even bother to get a warrant at that time. They just rebooted it because they believed that the Knotts and Kerr line of cases allowed them to do this. Our position is those cases involve a significantly different technology. And what we have here, as I said, is pervasive monitoring and recording, which is not what was before the court with Knotts and Kerr. Those were simple trips through the highway in which the police could keep the car within oral range the police were really tailored Antoine Jones the vast majority of the time. They said what they were doing, they just let the machine record relentlessly where he was going over time.
Steve, let me interrupt, because I think we're going to focus in a minute on Carroll and the other cases specifically, but in terms of the broad Fourth Amendment concern, Melanie Wilson, did the DC Circuit get it right?
I agree. I think the bottom line is they did get it correct. The issue was the search and whether there's a justifiable expectation that a person can travel for 28 days and have their movements watched and recorded essentially. I think it's a tough issue because the circuit court went on to describe a mosaic theory where they essentially said that, well, even though the Supreme Court has said that if you move in a public place where everybody can see you, you have no reasonable expectation of privacy. If you add up the individual parts, the whole is something very different than individual parts. And I disagree
And we're
with that
going
part.
to focus on the mosaic theory in just a second, because it's a very significant part of this.
Can't hear, there's a lot of static.
Turn your mic off.
It's my mic that's the second?
Yes, turn your mic off, please.
Turn it up.
Off.
Off.
Yes.
You can use
You
mine.
mean I'm going to have to belt it out? Because I'm guessing none of you can hear me then. I think you may be able to. Jake, is that okay now?
Much better.
Okay. Sorry, Melanie.
No, so the bottom line is I think they got it right. I don't, that does sound better.
Sorry.
Out loud. I'm not sure I agree with their reasoning. I think they maybe went a little further than they needed to in explaining why this pervasive surveillance is something that we really do have a reasonable expectation of privacy. We can move around without it. I would have stopped short of that, but I think the bottom line is they got it right.
Yeah, Orin, I'm guessing you're taking a different view of this.
I think you could reason to either conclusion from the available legal materials. If you're a lower court, I think you're pretty much stuck with the Knox-Caro line that the court drew. The court said pretty clearly, you don't have a reasonable expectation of privacy in public. And the DC Circuit had to pretty much invent a novel mosaic theory, which I think is extremely unlikely to be adopted by the US Supreme Court, in order to try to get around that holding of the Supreme Court in Knox. To my mind, the real question in this case is, should the court overturn Knox, or at least sharply limit Knox to much more simple technologies that don't have this sort of invasive potential? I think you can basically get either result, but I think the basic line drawn by Knox and Caro is actually a pretty reasonable Fourth Amendment line to draw, that the government can monitor individuals in public, just like they can watch people in public. So they can't monitor people in private, they can't monitor people in homes. That's not the only line you could take, but I think it's actually a pretty reasonable line that the court drew and might continue with today.
Well, let's talk a little bit more about those cases. You mentioned the two, Carroll and Knox. It's an oddity that all the cases here seem to start with the letter K. There's the Katz case, really the first one, the phone booth case. But then there's another case too that's mentioned, and I guess I want the three of you to take a look at the package, and that's the Kylo case, the imaging case, imaging inside the house but coming outside the house. And Melanie, let me ask you to take a stab at when you put these four together, whether you buy the mosaic theory or not, which we're going to get to in a second. Does the DC Circuit get it right in terms of applying those four as a package?
I still think they do. That is, if we lose our expectation of privacy if we're in public and we keep it if we're in private, the one thing that Justice Scalia points out in Kylo, which is the heat imaging, you can't look inside someone's home, essentially our perceived information is coming out from using a technological device that perceives that. He still says the means matter. That is, he points out that if you want to know who's in the house, you can have surveillance, people can surround the house and watch who comes in and who goes out, but you can't necessarily bust in the door and check it out. So I think if we read these together, we are looking at expectations of privacy, but we're looking at the means, right, with which the government is infringing on this expectation of privacy. So I think they fit together nicely, and I think that's the difference really with the GPS monitoring.
Orin, you mentioned Carroll and Knott. Are you moved at all by looking at Katz and Kylo and two very different kinds of cases, but in both cases really quite pro-defendant?
Well, I mean, the ultimate question in the cases is not whether they're pro-defendant or pro-government, it's what kind of rule is the court talking about. Kylo, I think, is so far removed from these sorts of facts. It was a thermal imaging device used to detect the temperature of the home, the wall, exterior wall of the home. So you can take that as being a case about the need for privacy protection in a home, in which case that lends no support to Jones's argument, because of course this surveillance was in public. Or you can see it as about sort of the need of the Fourth Amendment to adapt to changing circumstances, in which case you can say it does apply. So I think those two are roughly in equipoise. I don't think Kylo really tilts one way or the other.
Now, Steve, in your argument, you're really pulling all of these together. I hope you're.
I think
Again,
our
if you
position-
turn the mic towards you, that'd be helpful.
Our brief will be filed on Monday, but I think it's fair to say this, that we view Kylo as standing from the proposition that the Fourth Amendment does keep pace with technology, and as Melanie points out, means do matter. But the Fourth Amendment was designed to curtail was abuse of power, arbitrary abuse of power by the government. And for that reason, before the government agents should be allowed to invade a person's property or to invade a reasonable expectation of privacy, there really ought to be somebody to balance and to assess whether they have shown a particularized need to do that. And what Kylo points out, in one part, Kylo involves the home, which is certainly somewhat different. But in Kylo, what Kylo also adds is this: qualitatively, what kind of a life do you want to live under the Fourth Amendment? And what's the Fourth Amendment designed to do? And our Fourth Amendment is designed, to some degree, to protect against arbitrary invasions and privacy and security. What you have here is a pervasive monitoring and recording of somebody's movement in public. Now, it may be, and in fact, I would grant that under Kerr and Knotts, that an individual discrete trip or two on the highway, anybody can observe that. But nobody realistically expects the police to be tailing him or her for 24/7 for weeks on end. That's just unrealistic. The police don't do that. And if one applies Knotts, Kerr, Kylo, and Katz, you look to what society is prepared to accept as reasonable. And it's objectively reasonable to believe as follows: that your next door neighbor isn't going to be taking your car and turning it into a radio beacon so that he or she can follow where you are. And that's a civil tort, or it could be a criminal trespass. That's reasonable. It's also reasonable to assume that the police aren't going to be following you 24/7. That's the message. We don't say that the police can't follow you. They can follow you as long as they want visually. But here, this isn't a tail. This is an electronic search. Make no mistakes about it. That's what it is. It's a substitute.
Well, Steve, let me press you a little bit farther, and then I'm going to ask Melanie and Orin to weigh in as well. The notion of this mosaic theory, which, apart from the result, it's a theory that has really gotten a lot of controversial comment out there. It's the notion that you don't look at one day or one action, but you take it all as a whole. Well, it's a pretty unusual theory for the Supreme Court. And there's some language out of the D.C. Circuit, and here's a pretty good phrase. When it comes to privacy, however, precedent suggests that the whole may be more revealing than the parts. What may seem trivial to the uninformed may appear a great moment to one who has a broad view of the scene. Steve, is that really grounded in the Constitution, that theory?
I think what they're interpreting, what Judge Ginsburg was saying was, you look to the realistics of the situation. Is it constitutionally inferred? Yes. I mean, you start with this proposition: a basic piece of data may not mean much, but an agglomeration of data may mean a lot. Why did they put a GPS on Antoine Jones's wife's car? Because they wanted to figure out where he was going over time, to have to associate him with persons and places. They expected to sit back and have a large accumulation of facts which they could build their case on. And our view of it is, if you're going to do that, people don't expect you to do that. Society doesn't expect that as reasonable. Police are going to turn your car into a radio beacon.
Or you have a different view of the mosaic theory.
Yeah, although I'm undecided as to which side should ultimately win in the court, I think the mosaic theory ultimately just doesn't work, and here's why. So the Fourth Amendment basically divides the world of police practices into things that don't require a warrant and things that do require a warrant. and then tells the police, if you want to get a warrant to search a really private place like a home, you need to do a lot of the things that don't require a warrant until you get probable cause. So the government essentially has to create a mosaic in their warrant application in order to get a warrant to search the private places. What the court says in creating this mosaic theory is individual pieces can amount to significant evidence that really shows what a person is doing. But of course, that's the purpose of the warrant requirement, is to require the government to create the mosaic before they can get the court order that lets them go into the really private places. So I don't think that theory works, and I think part of the problem of it is if you think that a month of surveillance is too long, a month creates the mosaic, what about a week? What about a day? What about an hour? It's like a law professor's dream. You can imagine all the incredibly annoying Socratic questions the professor had. Where do you draw the line?
Oh, that's tomorrow in class.
and even the DC Circuit, they don't try to draw the line. And as far as I know, even proponents of the mosaic theory don't have a say as to, don't know what the time is at which the line should be drawn. So I think that idea of sort of gradually accumulating non-searches that at day 5, say, are not a search, but then by day 30, retroactively makes the whole thing a search. It's a novel, interesting academic theory, but I don't think the justices are going to buy it, and I don't think it's rooted in the Fourth Amendment law.
Melanie, you also have some hesitancy about the theory.
I do. I tend to agree with Orin, but I think that they rely on a Freedom of Information Act case where the government basically said, look, the sum of the parts, or once you put them together, it makes more of it than it otherwise would be, which that's completely inapplicable. And then they rely on Smith versus Maryland, which is the pen register case, which actually I think proves the opposite. That is, the pen register, the government is taking and gathering information just on the numbers that someone called, and they put them all together and say, well, you could kind of make a picture of this. And the Supreme Court said, well, you basically assume the risk of dialing into the phone company. The phone company will turn this information over. They rejected it. And so I don't think there's any basis in precedent for this mosaic. I agree with Orin that it's interesting, it's novel, it certainly holds appeal to make arguments, but I don't think it's really in any of the court's precedent. I think in short that the defendant may win, but it won't be, I think,
Well, let me pick up on some of each of the three that you mentioned. Each of you talked about the timing, and there's some relevance. Is it an hour, is it a day, is it a week or month? That's okay. But I want to shift it a little bit. In one of the early GPS cases, and it's only about 8, 9 years old, although it's early in this area, it's a case called United States versus Garcia in the 7th Circuit. And Judge Posner was not terribly sympathetic to the argument that the defendant made. It was a short-term surveillance, didn't involve major physical intrusion to put the GPS device in. But what he did say was, this isn't that case. But if there does come a time where we're talking about mass surveillance of large numbers of people, then we really may want to rethink how the Fourth Amendment applies to that. And I guess that's the strand that and I'll start with you on this one, Melanie, that I want to get to here. Why does that matter? I mean, it's not going to be a class action. It's going to be individuals bringing motions to suppress evidence, I assume, or to dismiss. Why should we care if it's one person or 100 people?
Well, I guess I would cite Justice Marshall maybe again in the pen register case, but he says, well, look, can the government just stamp out someone's reasonable expectation of privacy by just putting out a notice and saying, look, we're going to do this, so everybody be on notice that you no longer have privacy? I mean, I think there is that issue that we do need to be worried about the means. We do, as Steve says, look, the Fourth Amendment is about protecting privacy and protecting dignity, and as we improve technology, we have to have some limits. So the court's going to look for limits. I think those are things that we're worried about. I still don't think the mosaic is necessarily the means of protecting that. I think we can protect it on at least either limiting the case law that we have or following the principles that the Supreme Court has already set out.
Yeah, Steve, Judge Posner's concerns?
I have the utmost respect for Richard Posner's decisions. In the days that I was reading Fed Thirds for fun at night, I enjoyed his elegant writing. On this one, I think he's wrong, and let me tell you why. First of all, the defendant, the appellate in that case, essentially conceded that Knox and Kerr were controlling and didn't really forcefully address the issue of GPS, which is something that Judge Ginsburg noticed in the Maynard decision. But more importantly, what Judge Posner addressed, or what he decided was, he said, well, what Knott's really meant was you can tail somebody, you can put with a beeper, that's the same as the GPS effectively. Knott's reserve a question of, if the time comes when dragnet surveillance occurs, then we'll revisit the issue. And Judge Posner thought that dragnet meant mass surveillance. But as Professor Renee Hutchins pointed out in a really well-written larger article that we cited in our brief that Judge Ginsburg and the panel unanimously agreed with, that's not at all what Knott said. What Knott said, that dragnet, in the context of a Knott's opinion, could well include an individual search. They just talked about dragnet methods of surveillance. One would have looked at dictionaries that were even in use in 1980. Dragnet was defined to include searches of an individual. So one doesn't have to have mass surveillance. One can have surveillance of an individual, the dragnet surveillance. But as somebody pointed out, to me, the real difficult issue in this case, of course, none of it's easy, but the most difficult issue, where do you draw the line? As Orin points out, is it a month? Is it a week? You don't have to do that. You could take the reasonable position, or it's easy for me to say it's reasonable, but the position that putting this on your car is wrong to begin with about a warrant.
Well, hold off on that. That's coming up. But Orin, let me go back to you. If there's evidence in a case like this case, the next one coming down the road, and the detective from Fairfax County or wherever it is, or DC, says, yeah, we put on 200 cars. What the hell? They're cheap, they're accurate now, and by God, we came up with something really interesting. Is that going to weigh in on the court's analysis here?
I think, if you're asking sort of what is the Supreme Court likely to do about that kind of a problem, I think the scope of the surveillance in terms of how often is law enforcement using the technique has a role in shaping how the justices think about the problem. If it's something that's being done really often, they think it's a bigger problem than if it's something that's not being done all that often. So I think it has some impact on them. The hard question is where in terms of the doctrine do you take that sort of an instinct or fear of incredibly wide-scale surveillance, and where does it make a difference? And I think it makes a difference in saying that the use of the technology is a search because it is so widespread, because it can be so invasive. Effectively, the use of the technology and its widespread use going to the threat to privacy that it creates. And then there's room in the doctrine for saying that that's relevant to whether it's a search, even though formally speaking the doctrine doesn't really care whether a technique is being used once or 1,000 times or 1,000,000 times. So the widespread use is not clearly doctrinally relevant, but I think it shapes how the justices think about it.
Yeah, Posner was clearly moved by that, in terms of a specific concern. Well, let me start shift gears a little bit. Orin, I'll start with you and go down with the panel here. There have been some who've argued that the problem in this area is not so much the surveillance, but it's the installation of the unit. That somebody has to physically clamp it down on your fender with some sort of magnet or Velcro. There are various ways of doing it. And that's really my question. How important is that? Because indeed, as the DC Circuit mentioned, there are now these sort of futuristic sounding darts that you can shoot out, and they will go in. But as we all know, there are lots of devices that we use that are imminently trackable. And who knows what those 2012 vehicles are going to be having. And they may not have to install anything. Does that matter?
I think the installation of the device does matter. And if I had to guess, I think this case generally is going to divide the justices, and it's unclear which way they'll go. But I would guess that the most defendant-friendly argument that conservative justices are going to be particularly interested in is focus on the installation of the device, not the use of the device. And the idea would be, this is an interference with your property. The government is saying, we're going to turn your property into our means of surveillance, and they are attaching something to that property. In the Fifth Amendment setting, that would be a taking. It would be an interference with your private property, therefore a taking. And the difficulty is trying to fit that into current Fourth Amendment doctrine. The government isn't getting any information from the installation, so it wouldn't seem to be a search, which usually requires obtaining information. The question becomes whether it's a seizure, which requires substantial interference with the possessory interests in property. That usually means control over the property, either taking it away or not letting somebody who controls it access it. And it's not clear that that is occurring here either. It's the property isn't so much being seized as it is that sort of it's the rights of exclusivity are being interfered with. The property interest is being interfered with without an obvious seizure. So that issue as to whether that's a seizure or a search, I think is going to really trouble the more conservative justices. And one thing to watch out for in the dynamics is whether you'll get a couple votes on the sort of conservative justices on that theory, a couple votes from the liberal-leaning justices on the theory that it's a search to use the technology, and it might be that there's a mix based on those different arguments.
Yeah, interesting. You can see the court kind of really splintering on this one. Melanie, your take about the installation part of it?
Yeah, I think it's definitely troubling, but I agree with Orin that if it has to be a meaningful interference with the possessory interest, I'm not sure by just attaching some small device that we wouldn't even notice, which is part of the point, we don't know that it's there. It doesn't fit neatly within the definition that the court has used for seizures. It strikes me at some level as it must be so, but if we look at the prior precedent, I don't think it fits neatly. So I think it will definitely trouble the justices, but I'm not sure that I would be comfortable, at least unless they expand the definitions they've used in the past, saying that that's a seizure. As Orin points out, it really doesn't, that's not the portion that gathers information, so I'm not sure that we could fit it in with a search. So at some gut level, I'm troubled by it, but I don't see how it fits in with the court's prior precedent.
Well, Steve, is it a seizure?
We certainly think so. It's a seizure or a search and a seizure. You look at the classic sense of it, it's a case called Silverman versus United States, which was decided a number of years, the Spike Mike case, which was decided a number of years before Capps. It's Silverman, it's still good law, and what Silverman says, if you're usurping somebody's property and dominating it and controlling it, that's really what happened here. The government usurped Antoine Jones' wife's car and indiscriminately monitored and recorded every movement he made. That could be a search. It could also be a seizure in the sense that it is a seizure in the sense that it is a meaningful interference with one's property rights. Property, at the time the framers adopted the Constitution, meant the right to control or exclude or prevent others from taking your property. And here, without Antoine Jones' knowledge or consent or that of his wife who owned the car and who drove the car, the government, as I used that phrase I alluded to a moment ago, converted it into an involuntary radio beacon. So we view that, it didn't prevent them from driving the car, but it certainly was a meaningful interference with their possessory right.
Well, we've been talking so far about the action of the police here arguably requiring a warrant or not requiring a warrant. Hypothetically, still months to come before the Supreme Court decides. Let's suppose the Supreme Court decides that a warrant is necessary. And my question to the panel, and Steve, I'll start with you and kind of go this way, is if you're a federal district judge or a state trial judge, and a request is made for a warrant in connection with a GPS device, what kind of restrictions are there going to be? I mean, what is it you really are looking for? You're the advocate in this one. We'll get your colleagues to do that.
Well, first of all, would I be hoping by that time that Congress would have responded to the decision by doing what they did with Capps and Berger versus New York were announced, which is creating a carefully thought out legislative scheme. That stated if that didn't happen, what I'd be looking for would be, have they met probable cause? They've shown me that it's more likely than not that there's criminal activity afoot. Two, have they shown me that the use of the GPS is appropriate under the circumstances? Have they exhausted other available tools? Do they really need this? And most importantly, what steps have they taken to minimize intrusion on other people's rights if it's possible? In Antoine Jones' case, his wife owned the car, and his wife drove the car some. There were no provisions were made to minimize interference if she was driving the car. And I think lastly, I'd ask the agent, well, how long do you really need it for? Do you want to have it on forever? Or do you want to have it on limitlessly? Which of course would violate the Constitution, but I would say, what's a reasonable period to have it on? Now, in this case, the warrant did provide for 90 days surveillance. It just let the warrant expire and didn't do anything about it.
Well, Steve, before we go on, note what Steve has now done, very artfully, I will say, he has taken the federal statute we have currently for electronic eavesdropping, which is a direct result of the Katz case, the phone tap case, and he's imposed 3 requirements, and I guess those are the ones I want to ask Melanie and Orin to comment on, which are in the statute and are very routine, but usually aren't present with warrants generally. Number 1, police officer, have you exhausted other less intrusive means before I give you this warrant? Number 2, how are you going to limit the intrusion with respect to other people, not just this person? Again, typically, if you get a warrant to search your house, we're not worried about who else is living in the house. You get to search the house. And 3, what kind of time limit are we talking about here? Again, with a search of a house or a car or a bag, you go in, you search, and it's kind of over in a very brief period. Not true with electronic surveillance. Melanie, if you were fashioning a warrant, if Congress doesn't act, would you include all this?
I'm not so worried about the other less intrusive means, because I think, unlike a wiretap, we really are talking about something that is less intrusive. That's really what makes the case, I think, so interesting, is that we are traveling in public. If we had 1,000 law enforcement officers, maybe we could watch almost everything that's going on. I don't think everything, but most everything. So I think the restrictions should be much lower. I do think a time limit is a reasonable restriction that would be something. I mean, even when you execute a warrant to do whatever it is, or something, you have to do it within a certain period of time. So that I think that's consistent. And then in terms of limiting exposure of other people, I think that is appropriate in the sense that arguably, if they're not just attaching the GPS and then doing no surveillance of their own, then hopefully, and I don't know exactly how GPS works, but I assume that you could determine when it is recording or not recording. I might be wrong about that. But if that's possible, then that would be easy to carve out the time period during which somebody else is traveling in the car. And I do think those things make it reasonable, and since the Fourth Amendment and bottom is supposed to be about reasonable government intrusion for the right part, for the right
But
reasons.
that's a pretty restrictive warrant you're now talking about. It's not the warrant to search the house kind of warrant.
Well, in the sense that, you have to execute the warrant within so many days, you have to execute it during the day. So I think there are some typical restrictions on warrants that would generally apply, or at least we could analogize to those. I just don't think that the, show less intrusive means that we have with a wiretap, I don't necessarily think that that's necessary.
Yeah, so approaching this just from a policy standpoint, assuming there's a probable cause requirement, I would say the only one of those issues that I think is really needed would be the time period, which is inherently something that has to come up with something that occurs over a period of time. So maybe 30 days or something like that. I don't think I don't have a terribly strong view of that. I mean, I think the idea of minimization requirements, exhaustion requirements, which we have for the wiretap setting. Think of the wiretap setting. It's communications with other people, right? And maybe a small percentage of someone's communications are likely to actually involve criminal activity, and a lot of it is going to be pretty private communications. I think the location of a car on a public street is not nearly as invasive, so I'm not as concerned from a policy standpoint with some of those other requirements. I would say that even if the court says that there's no search or seizure involved here, I think a statute should be passed. I think the policy question is independent of the constitutional question, and I think I'm worried about two different things. I'm worried about government use of this. So I can imagine, for example, a statute that says the government needs reasonable suspicion to determine the location of a car, to use a GPS device for a certain period of time, or probable cause. I don't have strong views as to which is better. But I think that it should also prohibit private party use of GPS surveillance devices. We just haven't seen a lot of this because the GPS tools that would record the information internally right now are currently only sold to law enforcement. It's not, when you get a GPS at a store, you can type in an address and it'll take you there, and it'll tell you where you are on the road, but it's not keeping a record of where you were every 10 seconds or so. So eventually that technology will be widely available to the public, and I want to make sure that individuals aren't, exes or people that aren't trusting each other, all the kind of cases you can imagine them now as to why people snoop on others. You can imagine, instead of just checking somebody's email or trying to log into their Facebook account, they're sticking a GPS device to see where they're going. So that should be a crime as well.
Well, I must say, we have a whole bunch more questions, but we don't have a whole bunch more time. probably a good moment for those of you in the audience to weigh in. Questions that you all have? Okay, we can go on for a bit, but it would be nice to hear from you. Yeah, Tim?
Professor Kerr, is there any
And
argument?
again, we'll go from one and then to the others as well.
Is there any argument to, I mean, earlier you were talking about the police having to, or worrying about a mosaic of different sorts of searches. Is there any argument to maybe courts looking at like pieces of evidence forming a mosaic? Or are you worried about courts not being able to differentiate between different types of evidence?
Yeah, I just don't know how you group the evidence in any way. So imagine an investigation where there are 10 police officers. Do you include their ocular surveillance? They're just watching, right? Do you aggregate that over time? Do you just consider GPS? What if it includes obtaining telephone numbers dialed, the pen register information? I don't know of any way of sort of coherently saying only this is considered and here's how you determine when you get to the warrant point. In part, the problem is the technology is always changing, right? So what a GPS device does today will be different from what it does tomorrow.
And will be a lot cheaper. Yeah, I mean, seriously, one of the issues that has come up now in the last 10 years, they have gotten extremely inexpensive, and you don't need a whole lot of labor for someone to manage it. So it's much more widespread use than it was. Melanie, your sense of that?
Well, I'm not sure. I think if you have a non-search and you add up a bunch of non-searches, you still have a non-search, right? So I don't know that it necessarily matters whether you're just observing or whether you attach a pin register and get just the numbers. I don't know that it so much matters. I guess if the court buys into that, then the problems Orin has pointed out are endless. I mean, this group and that group or this group, I mean, it seems to me that non-search plus a non-search is still a non-search.
Well, I don't want to get bogged down in the mosaic concept excessively. I mean, to me, the question is twofold. If they're putting one of these in your car, is it search and seizure, or if
You want to get the mic a little bit closer, sorry.
the question is twofold. If they're putting one of these devices on your car to remotely, electronically, relentlessly monitor you, is that a search or search and seizure? And if they're doing it automatically, compiling an enormous amount of electronic data they couldn't otherwise get and recording it, because the GPS does record, is that a search? I mean, the mosaic theory to me, that issue's a sideshow. The question is, what's going on here? And what are they using the GPS for? I think we all realize they're using it for long-range surveillance because they want to draw inferences from that. That's the mosaic in a way. It's sort of like an impressionist painting. You can look at a single little dot, it won't tell you anything. You sit back, stand back and look, and you can see a lot. If you like impressionist painting.
Which we all do. Yes.
I'm wondering, this is just for everyone, really
So
what
maybe Steve will start with you and then go this way.
It's better with Orin. He's
what really distinguishes the GPS from the beeper? What makes it rise to the point that it becomes so much more invasive? Even perhaps it could be argued that it's less invasive because it's on the outside of the car rather than put inside of the property.
Well, in the beeper cases, the issue of installation wasn't an issue. It was that they were transferred by government informants in cans and then ultimately ended up in the people's vehicles. What's different about a GPS is as follows. Number one, it's a complete substitute. In a beeper case, you have to have the proverbial police officer with his or her colleague and a box of Jelly Roll donuts in a patrol car detailing it. That's not true of the GPS. It's an automated search device. The police can be watching football. In fact, in the New York case, people being Weaver, they were watching football while the machine was just recording where the suspect is going. Secondly, it's a recording function. It records with precision where somebody is gone. It's not a sense augmenting device. It's not akin to binoculars. It's a sense supplanting device. And to that extent, I respectfully suggest to you that it's light years away from GPS. Again, think of it. Think of it this way: the pervasiveness of it all, the intimate data that it gets over time. It's far different if you go in a court with a police officer with a beeper. He or she's got to say, "Well, that's what I saw at that particular time." In Jones's case, there's 3,000 pages of data that showed within 7 to 10 feet where he was every 10 seconds of the day.
Orin, let me jump to you and then Melanie.
Yeah, I mean, I think it's tricky because as soon as you draw the line between the beeper and a GPS surveillance, what do the police do? They'll go right to the one side, the radio beeper side of that, and say, okay, we'll do this without a warrant. And then you say, okay, well, you're allowed to do that because we drew the line there. So I think it is tricky. To my mind, the simplest way of ruling for the defense, one way is to say the installation of the beeper is a search or seizure. The other is to say that Knott's is overturned. We don't really have beeper cases anymore. That's not a technology that's in use. So if you overturn Knott's, you haven't actually changed the outcome of any practical investigations. You've just said that for the 2011 technology, there's a different rule than there was for the 1980s technology. I think that's actually a simpler way of doing it than trying to come up with exactly what is it that distinguishes the beeper from the GPS.
Well, I think I agree more with Steve. That is, at least previously, the cases we look at, we say, well, gosh, we've assumed the risk, we've lost our expectation of privacy, because look, the police can be out there and they can watch us, or they can hear us. They might need to use glasses, they might need to use binoculars, but there they are. It's basically this augmentation with the beeper, whereas now we can sit at home apparently and watch ball games. And I think that's substantially different for one reason. We don't assume the risk that the police are just going to sit at home and monitor us. I mean, I think there is a difference. If we're using something to augment our ability, the police's ability to investigate, I think that is fundamentally different from a substitution. At least I do.
Other questions?
My question kind of tags on to that, but what about the law enforcement kind of viewpoint of this and how you guys kind of touched on this when we were talking about Congress and legislature, but at the same time, you know, these things could become less expensive than manpower. And I think Professor Wilson pointed out, well, if you had 1,000 police officers on the street, then you would monitor all of those things. But putting a GPS in somebody's car is significantly less expensive. So, you know, if you're doing a balancing test between privacy and government interest, it's less expensive and more accurate and reduces a huge margin of error. And in addition, I think these kind of technologies improve the access that the government has to larger crimes and conspiracies versus smaller crimes, you know, like, you know, stop and frisks and like random, like small amounts of drugs that are found on persons. So how would you respond to that?
Yeah, Melanie, I want to start with you.
Well, first I would point out that the Fourth Amendment is not to protect the police, it's to protect us. And you're exactly right. And I think the Kylo case, which just had basically a very primitive thermal imaging machine, answers this question. That is, at that time, you could just see heat, basically, and tell maybe which areas were the hottest, and probably tell whether a human being was someplace. Well, now the technology is so good that we can probably, and I'm not an expert on this, but we can probably see people pretty readily. I think there's thermal imaging where you can see inside cars, and so you're exactly right. For not too much money, it certainly would be very effective in stamping out crime. As people drive by in cars, we could just point the imager at that. We could see whether they're carrying Great Danes or cocaine or just what. So it would be very efficient. But I think the problem is, if there is going to be privacy that's protected by the Fourth Amendment, then the police there have to be limits on this. And so we have to find those reasonable limits. If we really are only worried about solving crime, then all this technology is great, and we should just, you know, open it.
Couple points. I agree with you wholeheartedly that society should combat crime. The question is, how does one do it? And I respectfully suggest to you that those who frame the Fourth Amendment wanted to strike a balance there. They wanted to make sure that government agents didn't act arbitrarily. Now, let me use a figure that my colleague Orin Kerr referred to the other day at a seminar I attended. I think there's 150,000 federal law enforcement agents that have arrest powers. Just think of it, what kind of a country we have if all 150,000 or 105,000, Orin will correct me, I'm sure, have the ability to walk around with unfettered discretion, put one of these into your car. I mean, there's nothing
That's
more.
the federal level.
That's right, and at the state level, I'm pretty sure I remember this number, I think it was 650,000, is that right, Orin? So think of the states that, there are some states like New York, Massachusetts, that have Washington, Oregon, so you have to have probable cause and a warrant. Well, let's assume there are others who go and there are others who've gone the other way, Virginia being one. There's 600, so let's take out the New York people, let's take out the Oregon, Washington, Massachusetts law enforcement agents. How do you feel about a country in which there are 525,000 people who can walk around sticking one of these devices under your car at any one time without somebody to say, wait a minute, is that right? So law enforcement is not hampered by anything we're seeking. They got a warrant in this case. They just decided for whatever reason they didn't want to adhere to it. Or they let it expire and figured they would do it on the cheap. And our view of it is you can't do it that way.
And I would say, I think the government perspective is a perfectly reasonable one, which is to say, listen, we're allowed to watch bad guys in public. In fact, we're supposed to do that. That's part of our job. And so if we have tools that let us do that cheaply, what we are doing is...
And more accurate.
And more accurately, we are catching bad guys and saving the taxpayer dollars, neither of which are bad things. So that ultimately the same rule should apply whether it's watching through eyesight or using a beeper or using a GPS device. One of the interesting things about this, I think, is that the GPS devices that law enforcement uses were created at a time when it's thought to be the rule that GPS devices are not regulated by the Fourth Amendment. Let's say the Supreme Court says, well, this is now regulated by the Fourth Amendment, and they pick some aspect. For example, let's say it's the fact that the GPS device records the location every 10 seconds or 7 seconds. Well, you could then just reconfigure, just change the software so that it registers location every 5 minutes, or maybe only during the daytime. That's just a software issue. So the notion of what a GPS device is something that itself is really flexible, and depending on how the court writes a rule, it could be one where it looks like it's one rule, but actually you can just change the software and get a different result depending on how the GPS device is configured.
We have time for about one short question and 3 short answers.
I guess, well, touching on accuracy really quick is, it's also much more accurate than eyewitnesses as well, which they could use. But I think I'm persuaded a little bit by not so much interested in what a reasonable time frame would be from your perspective if you were to put it in the statute. Because as we know, investigations can range, and there may only be one transaction every once in a while. So where is that line if the Congress was to draw a line on what would be a reasonable time frame?
30 seconds for each of you. Steve, let me start with you, and we'll go down the path.
I'd say 30 days with the right to reapply.
Less than 30 seconds.
I think the right to reapply is the main thing, that you have to go back to the court and get an extension, so I don't really know that the days matter, but you can just go back and basically reapply.
14 and a half days.
And on that happy note, our time has zipped by. Our panelists, thank you all so much.